Hi, good afternoon, and welcome to episode number 54 of At Your Service with Haber and Martinez. I'm Haber, that's Martinez. Hey, I got it right this time.
There you go.
Good to see you, Eduardo.
Good to see you, man. It's been a while.
Yes, it has. We took a 2-week hiatus, and with that, I'm going to actually give the title of our show today, which is Rule 3s / 3.850 and SYG / Stand Your Ground / Statutory Immunity Hearings. And the reason that we're going to have these discussions and bifurcate the show today is because we weren't here for the last 2 weeks. On October 31st, on Halloween Day, I was subpoenaed as a state's witness to appear in what is called a Rule 3 hearing, and we had to cancel the show on that Monday because of that. And so the first half of our show, we'll talk a little bit about Rule 3s, what they are, and what my experience was. And of course, what your experiences are, both as a defense attorney and formerly as a prosecutor, if you ever had an opportunity to handle one on the state side. And then the second part is Stand Your Ground. Now, we've already done a show on Stand Your Ground, although it was early on. It was one of our earlier episodes. I think it was episode 7, where my former client, Captain Nick Marion, came on and spoke with us about his experience having physically gone through a Stand Your Ground hearing. Actually, Nick has indicated he'd love to come back and do another show with us. So maybe we'll take him up on that generous offer. So the second half of our show, we'll talk a little bit about my case that I had this time, not generically about Stand Your Ground, but I'll actually read the arrest affidavit to you because I know you've never actually read it, Ed. And then you can take give us your thoughts and impressions on it, and I can take you through what happened on that hearing. So with that, let's start with Rule 3s. And I'm going to read some stuff off because Rule 3s are a little bit complicated. Rule 3 refers to Rule 3.850 of the Florida Criminal Rules of Procedure. And basically what it is it is a mechanism by which to attack a judgment and or a sentence in a case given certain specific guidelines. It is not your traditional appeal. It's a secondary approach that you can take usually after an appeal, or I guess it could form the basis of an appeal. Good. Let me tell you what I know about Rule 3s, because there's two things I know about Rule 3s. The first is I know that I don't do them. And the second is I know if you do everything right, you should be able to avoid them. If you do it right at the trial level.
I don't know if you said it, but let's make sure everybody understands. So Rule 3 is basically a defendant saying, the only reason I was convicted was because my lawyer sucked.
I haven't gotten there yet because that's only one component of a rule.
I know, but I want people that are watching to stay tuned.
As I'm going through the statute, the rule will hit that.
But I know, but I want the people that are tuning in right now to stay tuned because it's going to get interesting.
Yeah.
You're going to hear a perspective from two lawyers who are going to, one, dissuade all of these myths that exist out there from clients, and we get it all the time, Michael, right? My lawyer did this or my lawyer didn't do that, and that's because he sucks and he should be disbarred. And we're like, no, actually, that's not a grounds for that. Or what are really truly grounds for ineffective assistance of counsel. So stay tuned so you can basically understand when really is it that the law says. Now, the common guy may say your lawyer sucked. The man on the street may say your lawyer sucked. That's fine. But when does the law say, you know what, your lawyer sucked? That's what we're going to get into.
So if you read the rule 3.850, it gives you several grounds that the rule is applicable for. And one of them, the first one, is that you are saying to an appellate court that the judgment that was entered or the sentence that was imposed by the trial court violates the Constitution. If that's the allegation that there's a constitutional violation, Rule 3.850 applies. Then there's jurisdiction, right? If you're going to say that the court didn't have the jurisdiction to try me or to sentence me, then that's another basis. Or if you want to say that the sentence exceeded the maximum that was allowed by law, that's another. Or if you want to say the plea was involuntary, that's another. Or if you want to say that the judgment is otherwise subject to, quote, collateral attack. So these are not direct appeals. These are specifically targeted issues. But the one that fits probably most often into what we call a Rule 3 is what Ed said, and it's called ineffective assistance of counsel. So basically what you're doing with an ineffective assistance of counsel claim is that you're saying to the appellate court, or actually when you make a Rule 3, first you're applying back to the very court that you were found guilty in or that you were sentenced by, right? Because it has to go back to that court. This is actually not an appeal to a higher court. It's a direct petition to the trial court to revisit that which they did based on whatever it is that you allege, right?
Right.
So most oftentimes this comes in the form of somebody complaining about a deficiency by their lawyer. So all of the other stuff is there. Again, I'm not an appeals lawyer. Ed may or may not have done an appeal in his life.
I've done a few.
I can barely spell the word appeal. Like I said, all I know is if you get it right the first time, you don't ever have to worry about an appeal. So that's
just to be crystal clear. I've never done a 3.850, but I've done appeals. I've done suppression of confessions, and I've done some other appeals, but I've never done a 3.850.
So have you ever been involved in a traditional ineffective assistance Rule 3?
You know, Michael, I don't think I ever was. I believe I was called in once to testify as a prosecutor, but I'll be honest with you, that was so many years ago. You could kill me. I don't remember exactly why I was called to testify. I do remember that it had something to do with not what I did as a prosecutor, but something that happened in the case, and they wanted me as a witness. I think it was I had a case and I passed it on to another ASA, and they wanted to know what if I had said something. I don't remember. But
hold that thought. Let's talk about the standard. So the United States Supreme Court has ruled on what ineffective assistance of counsel means. And it comes from a case called Strickland versus Washington. Okay. And basically what it boils down to is your Sixth Amendment right to have what's called effective counsel, right? You're not just entitled to a lawyer, you're entitled to a lawyer who knows what the hell he or she is doing inside of a courtroom.
Right.
So when it comes to criminal court, let's say you're indigent and you're in some county or jurisdiction where they don't have a public defender's office, and they just appoint local attorneys who sign up to agree to accept these cases pro bono, which is a really nice and lovely thing to do. But if you get a lawyer who's been practicing and doing nothing but real estate closings for his or her entire career, and all of a sudden they find themselves on a criminal case, having never been in a criminal courtroom, having never studied the criminal rules of procedure, you may not have effective assistance. You may have a counsel, but it may not be effective counsel. So here's the rule from Strickland. Okay, it's a two-part test that is required by the United States Supreme Court to show the counsel was ineffective. Prong number one is the lawyer's performance must be deficient and contain errors so serious that the lawyer did not provide adequate counsel as envisioned by the Constitution. And then prong number two is the lawyer's performance must have, in fact, prejudiced the defendant. So that's what the United States Supreme Court says. And here's a couple of examples, as Ed was throwing out a little earlier, examples of what courts have called ineffective assistance and have said, yes, this is ineffective. A failure to file an appropriate pretrial motion. We'll talk a little bit more about that in a minute, what the word appropriate means. The failure to convey or to fully explain the consequences of a plea offer. The failure to investigate evidence or witnesses which may be exculpatory. The failure to preserve the right to appeal. The failure to attempt to exclude prejudicial evidence. The failure to file a motion for a new trial, particularly where a prosecution case was weak and there was a reasonable probability that the motion would have been granted. A failure to move to strike witness testimony where the witness refuses to be cross-examined, and a failure to warn a defendant that a guilty plea could result in deportation if not a U.S. citizen. On the other hand, here's some examples of stuff that has been ruled not to be ineffective assistance. It is not ineffective for a lawyer to fail to call a witness to testify when the lawyer knows of the witness's testimony and makes a strategic decision not to call that witness. It is not ineffective for a lawyer to fail to interview a witness who is listed on an alibi notice when those witnesses are not available to testify. And it is not ineffective for a lawyer to fail to present a defense that the defendant was intoxicated, where that would have been inconsistent with the defendant's defense that he did not commit the murder that they claimed he committed. So those are some examples of ineffective assistance.
As we go through these examples, Mike, do you mind if I throw something out there? This is what I use.
example. So go ahead, throw out whatever
This is
you
what I
like.
want my clients to think of when they're sitting there trying to tell me that their lawyer sucked. Their lawyer was ineffective. I can give you two analogies. And one is certainly about sports, where most men and women would understand the analogy, but just in case, I have another one about
What
house.
about the other 68 genders? Will they understand it?
I don't know. But ineffective assistance of counsel is not saying I didn't have Tom Brady as my quarterback, but I did have an NFL quarterback. That's not ineffective assistance of counsel. You may not have had the best quarterback out there, and you wish you had Tom Brady, but for whatever reason, you didn't hire Tom Brady. You don't have Tom Brady, but you definitely had, an NFL quarterback. You definitely got a guy out there who's played quarterback, who knows what he's doing. He just made a wrong read. He threw the wrong pass. He did something, but he knows what he's doing. If you don't understand that analogy, it's like having somebody clean your house who's never cleaned your house. Don't complain later when the house is not clean if they've never cleaned your house. But if they cleaned if this is what they do for a living, if they're house cleaners and you hired somebody to come clean your house and you just didn't like how they cleaned your house, that's not ineffective assistance of counsel. They cleaned your house. You just have a very particular way that you want your house cleaned. Well, go find the right house cleaner. But that doesn't mean they were not a criminal lawyer. That doesn't mean they weren't a house cleaner. So keep those things in mind. It's got to be somebody who has pretty much absolutely no clue what they're doing. And one of the reasons, which I'm sure, Mike, you're going to cover, is before you take a plea or before you go to trial, the judge asks you a lot of questions under oath.
Well, I'm going to stop you there for a second, because the reason that the judge does that is specifically to avoid this issue.
Right.
So let's go with the issue of a plea, because that's one of the legitimate things to come in under a Rule 3, right? You're going to go in there and say, well, I took a plea, but my lawyer never told me that by taking this plea, X, Y, and Z was going to happen. We've also done a show, and we've discussed on many other shows, because it comes up routinely, what we call collateral consequences of criminal cases. Right. Things that can happen to you that have nothing to do with what's going on in the criminal courtroom. But if you have a lawyer who's been doing this, for any amount of time and really understands and has skill and experience, they're going to be able to express to you. For example, let's say that you have a commercial driver's license in the state of Florida. If you have a conviction for DUI, if you have a drug conviction, you're going to lose that CDL. That's going to be a problem for you. Now, the judge is not going to tell you that, because it's not a consequence of the criminal case. It's what we call a collateral consequence. In other words, that's an action by DMV that's completely independent of court. Now, your lawyer may or may not know enough to tell you this, and that may or may not be enough to get you a Rule 3 if you're not told and you do suffer this consequence later. But that's a good example of what a collateral consequence is. But how do they avoid that? Let's talk about deportation, because this comes up all the time. In fact, we had a couple of years where the Supreme Court gave us a window to vacate all those cases.
Green. The case was called Green with an E at the end.
Right.
I argued a few of those.
The judges got very savvy with this, because they got sick of getting these motions coming in and burdening down their dockets, and all of these cases coming back, which were already gone. So, nothing upsets a judge more, I don't think, than having a closed old case reinstated to their audit. I mean, that's just got to be one of the worst things. So in any event, what the judge will do is the judge will go through a very, very detailed plea colloquy with the defendant. They're not going to take the chance that the lawyer maybe did or didn't say X, Y, or Z. So when we take pleas now, the judge is another collateral consequence pursuant to the Jimmy Rice Act. You don't even have to be a sex offender, but you have to be told, if your case isn't even a sex case, that your conviction, if you do have prior sex convictions, can result in a civil commitment. So you could be taking a plea to a grand theft or to a cocaine possession or to a robbery or to a trespass even. And if the judge doesn't tell you about Jimmy Rice and all of a sudden you have a sex conviction in your past and this kicks that back up and now all of a sudden you're facing a civil commitment proceeding, that's going to come back on a Rule 3. So the judges don't like to allow that to happen, and they're not going to accept a plea without fully vetting that plea with you. They're going to tell you what the plea is. They're going to make sure that you and the court are on the same page with regard to every term of the plea. They're going to make sure that you know that you don't have to take a plea, that you had the right to go to trial. They're going to go through all of your constitutional rights. They're going to ask you specifically targeted questions. I mean, can't say they all will, but smart judges will. They're going to ask you whether or not you've had an opportunity to speak with your lawyer about everything and anything. Is there anything, would you like to step outside and talk to your lawyer before we go further, sir? And or ma'am, they'll probably do that 2 or 3 times during the course of the colloquy to give you that opportunity, because that way when you come back and say my lawyer never said X, the judge can rely on this colloquy. They will ask you if your lawyer has done everything that you have asked them to do. Is there anything you would like your lawyer to do that your lawyer has not done? And then one of my pet peeves, one of the things that really gets under my skin, judges will ask, in my experience, in felony court anyhow, here, they will ask the defendant whether or not all depositions were taken, or if they are aware that their lawyer did not take any depositions. Now, I am of the school of thought that I do not take depositions. Maybe 1 in 100 cases I will take a depo, but 99 out of 100, I don't do it. Why? Strategy decision on my part. And my reasons are my reasons alone, but they're strategic. So in that one,
by the way, you're not the only lawyer.
In 100 cases, I make the strategy decision to take the depo. But my default in 99 out of 100 is going to be not to take the depo. Now, judges will ask that. Why? Even though, and we'll talk about this in a minute, strategy decisions are not ineffective. But the judges still want to cover that base. Because you may come back later and say, and part of the Rule 3 that I was just involved in 2 weeks ago, one of the claims was that certain depositions were not taken. By the way, when you file a Rule 3, it's a sworn to motion. The movement needs to swear to the facts of the motion, and they have to with specificity tell the judge, well, here's what my complaints are, and then explain why you were prejudiced as a result of what did or did not happen. So one of the things here that was asked repeatedly by the client in this case was depots weren't taken of witness X, witness Y, and witness Z. And those were summarily dismissed by the judge. The movement was not granted a hearing on those claims because the judge in this case rightfully found, no, that is a strategic decision to be made by the lawyer. Unless you can prove that there was actual prejudice to you, that's not actionable in a Rule 3.
Mike, can I just briefly explain? I'm going to explain in 30 seconds or less why Michael doesn't take depots, and I understand completely with Michael why he doesn't, and why I choose to take depots. And I think Michael and I are at the opposite extremes. I think most lawyers fall in the middle. Michael doesn't take depots because Michael doesn't like to tip his hand. When you take a deposition, and I've seen a lot of depots as a prosecutor, I got to tell you honestly, Michael, 90% of them tip their hand. 90% of the lawyers tip their hand when they don't have to while they're taking a depo. The art of taking depositions, from what I've seen, is very slim to none. Every lawyer thinks he's great at it, but they're not. They do, right? That's why you laugh. They all think they're great at it, but they're not. So Michael doesn't want to take it because he doesn't want to tip his hand. And there's a lot of lawyers, and that's smart. That's a smart.
That's part of it. Another reason that I don't like to do it, 2 other reasons I don't like to do it, is not just tipping your hand. I find that it really prepares the prosecution because they read between the lines. So
if they're good and they're smart,
based on questions that you ask, the way that you ask them, things that you don't ask, in some ways you're preparing the prosecutor, but the other person you're preparing is the witness.
Right.
Because the witness knows who you are. They've gotten a feel for you. You're taking examination under oath with a reporter. I mean, it may not be in a courtroom in front of a judge and a jury, but it's still a serious proceeding. And the witness is, in an uncomfortable position having to give sworn testimony. So I'd rather get that witness for the first time on the witness stand in open court, preferably in a pretrial motion. Right? Because in a way, it's not so much that I don't take depots as I prefer to take my depo in a different form. Right? I will file, as long as I have a good faith basis to do it, I will file some motion that triggers an evidentiary hearing so that I can take that sworn testimony on the witness stand.
And therein lies the art form, the true art form of a deposition. The real art form of a deposition is to get the witness locked into answers without tipping or alerting the prosecution as to what your defense is going to be.
Or the witness.
Or the witness. And I'm not going to say here where everybody can come and find out how I do it, but I can tell you that I studied with somebody who's a master at depositions, and he taught me how to take these depots and how to do it so that they can't really see it coming. Now, obviously, if they know what I'm doing, if they studied with him, they're going to probably see right through it. But there's an art form to it, and I can tell you 90% of the lawyers that I see take depots don't do it. So the point is, what Michael does is a strategy. What I do is a strategy. So it cannot be an effective assistance of counsel because Michael is doing it for a positive purpose, for a purpose of helping you with your case. And he's right. You can tip them off, and that could hurt your case. You can prepare them to testify, and that could hurt your case. So it's ineffective. It's
so what happens? So what happens when the judge is doing the colloquy, right? And the judge says, "Well, you're aware that Mr. Haber didn't take any depositions in this case. Are you okay with that?" And the defendant says, "No, Judge, I'm not okay with that."
And then he's going to have to stop the colloquy and say, "Mr.
Right.
Haber,
but
you have to hire a lawyer."
I'm going to say to the judge, "Your Honor, this is a strategic decision by defense counsel. My client cannot force me to take a depo. You cannot force me to take a depo.
Right.
I'm not taking the depo in this case."
And at that point, I think what the judge needs to say is, "Sir, you have two choices: hire another lawyer. I'll appoint you a defender." That's all I can tell you.
That's really a great pro tip and a takeaway. Look, the most important thing that you can have with a lawyer is a meaningful attorney-client relationship. Okay, and in any relationship, as all of us know, because we've all been involved in relationships, whether they're boyfriend, girlfriend, husband, wife, parent, child, siblings, student, teacher, student, we have relationships in our lives. And if you want a relationship to work, you need to have effective, open, and honest dialogue. You have to have communication. So I don't flippantly just make decisions and not explain to the client the why of it. Not only that, but I always put it in writing. I give them emails about all of this because that way there can never be a question that I never told them or they didn't know. There's always going to be a paper trail. So, you have to have that communication. And if you have that dialogue with your lawyer, you're never going to be at this point, because when the judge says to you, "Well, you're aware depots weren't taken," your answer is going to be, "Yeah, my lawyer and I discussed that." Right? Now, the flip side to that coin is you're not going to be able to come back on a Rule 3 and say, after you get convicted, "Oh, well, I wouldn't have been convicted if only my lawyer had taken this deposition." Right?
Right. And even if you stay silent, a lot of judges may not ask you, "Has he taken depositions?" They'll say, "Has your lawyer done everything you asked him to do? Has he done everything you want him to do?" And then later you come back and say he didn't take depots. They're going to say, "Well, the judge asked you. Did he do everything you wanted him to do? If he didn't take depots and you wanted him to do it, you should have said it right then and there." So a lot of these things, that's why I'm saying at the end of the day, these Rule 3s usually boil down to the lawyer sucked. Because the other issues, for example, like he didn't have jurisdiction, I can't imagine any judge in any county that has more than 20 people in it not knowing that he has to make sure that they have jurisdiction on a case to take it and what jurisdiction means. Also, with the sentencing, they're very careful. They look at the guidelines. So a lot of these issues that are written in the statute, yeah, they're really important to be there. But 99 times out of 100, you're never going to have that. Actually, 99 million out of 100 million. You're never going to have that happen. The one that happens most often is, did the lawyer suck or was it trial strategy? That's the one that usually gets out.
So here's the other thing with Rule 3s. When you have a Rule 3, what you're asking for is a do-over, right? And so there's an adage, which we also did a show on adages: be careful what you wish for, you might just get it. Mm-hmm. So a lot of times, again, remember, when you take a case that is closed and is removed from the judge's and the prosecutor's audit, that's a good thing for the judge and the prosecutor. Why? Because every single day, 7 days a week, arrests are made, which means every single day in court, new cases have to be arraigned. There is a never-ending stream of new cases coming into the system. So judges and prosecutors have to have some sort of balance in terms of closing cases as they do with the new ones that come in. Otherwise, it's like if you have a boat that's filling with water and you don't have a bilge pump. You're bailing with a bucket, but if the water's coming in faster than you can bail, guess what? The boat's going down. And the same thing with the court or with the prosecution. If they can't keep up with their caseload and balance it and manage it, they get buried under the weight of it. They just simply crumble and crash. So every time you bring one of these new cases, what do? Well, you may get justice, but you may also piss off the judge and the prosecutor. They're not going to say as much to you, but it don't mean they can't take it out on you in different ways.
And that's the worst case scenario. Let me tell you something that could happen that nobody's pissed. Suppose, let's say, when I was a prosecutor, the prosecutor before me had the case, and he really didn't work the case up. Michael Haber was representing him. Michael called the prosecutor, and they said, listen, man, I saw the discovery. Can we plead this guy out to probation? And the prosecutor didn't want to do too much work. Why not? We'll plead it out to probation or something. Whatever. It could have been 1 year jail, something.
And now all of a sudden you got a great case.
But you're looking at 30 years with a 15-year min-man, or 30 years of prison. And now this comes back 3 years later, 2 years later, or whatever, because Michael Haber was a bad lawyer, and I get the case. And I'm looking at it going, oh, my God. Okay, well, I guess we're going to go to trial. Look, the prosecutor didn't get that. He didn't get that evidence. Oh, my God, there's video. He never asked for it. Jesus Christ, there's probably DNA. He never asked for DNA either. And they start getting all the evidence. And now the prosecutor's like, probation? No, buddy. I don't think you're getting probation. I got a good case.
Like I said, be careful what you wish for. You might just get.
As a pro tip, your lawyer should always, whether it's civil or criminal, you should always hear your lawyer say this at some point at the beginning of the relationship. Let me call the prosecutor and see how he feels. Let me call opposing counsel and see how they feel. That is a pro tip. I know Michael does it. I do it. We call the prosecutors because we got to know. We got to know whether we're going to poke the bear, or maybe we shouldn't poke this bear because the bear just wants to go home and hibernate, and let's just stay quiet. You've got to talk to the prosecutors. Even before you follow Rule 3, you should call and say, hey, listen, I think I got a Rule 3 here. This is what I got. The prosecutor might tell you, listen, you follow Rule 3, I'm going to try to put your client in prison.
So let me just briefly tell you that the case that was on for the 31st for the Rule 3 was a very, very complex criminal case. It was required me to bring in 2 other lawyers to try the case with me, one of whom was a appeals lawyer who my co-counsel and I, with the permission of our client, retained specifically to sit at the counsel table with us through the course of the entire trial, jury selection through either a not guilty or sentencing, to be able to sit there and field objections, have case law ready, and preserve the record for appeal. So we were well prepared for this case. And in fact, our client, who was looking at 160 years in prison, who had 8 charges against him, got acquitted, found not guilty on half of them, 4, was convicted of 4. And then after an extensive sentencing hearing where the state wanted 80 years, the judge gave him 8. So he did pretty damn good through the course of that trial. Now, that said, 8 years is a long time for anyone to sit. So this guy goes through the appeals process. He exhausts all of his appeals. And then it's now been 6 years and change since he went into custody. And he files this Rule 3. And ultimately what happened is I never even had to testify because the prosecutor who inherited the Rule 3, who, of course, 6.5 years down the road is not the same prosecutor who tried the case and couldn't care less about it, and probably has that thing going through his head about more cases on my audit and knowing how the judge is going to feel. Ultimately, they worked it out to an agreed resolution where they dropped the sentence from 8 years to 7 years. So basically, he's going to get out with credit time served now instead of having to do his last year. So it turns out in that particular case, the client gamed the system and saved himself a year, even though he really had no viable claims against us because our record was so clean during the course of the trial.
Right. But, again, whoever did it probably called the prosecutor and said, listen, I got this Rule 3, or he filed the Rule 3, and the guy do it pro se.
No. There was a lawyer on it, and there was like a 40-page written order by the court where they addressed each of the counts, and the court summarily denied several of them, for example, on the depot grounds. But in an abundance of caution, gave a hearing on the others because the court very wisely said, I don't want to wind up getting reversed because I didn't give this guy his day in court, even though his allegations are spurious.
They're actually on the Rule 3s, the court has to either A, make a factual finding, which it could be the record. The court could come in, sit at the bench after calendar and say, okay, I'm going now through Rule 3 of state versus so-and-so. I'm denying it, and these are my reasons why. They must. If they don't do that, they'll get reversed. Or they must give him a hearing. So I'm sure that the judge in this case found that, you know what, it's not, some of these are not that 100% cut.
Well, he flat out denied a bunch of them and just said, there's no hearing on this.
Right. And that's why he wrote it in the order, because he had to write it specifically in the order why he did it. And I guess he figured on some of these, you know what, let's just have a hearing just as an abundance of caution. Honestly, Mike, you and I have been doing this for years. Very rarely are 3.850s granted.
So let's, before we get on to the second part of this show, I just want to reiterate a couple things about Rule 3s. One, if you do it right the first time, if you hire a lawyer who knows what he or she is doing, if you have good communication with that attorney, if you ask relevant questions about your case, and even better yet, if you don't need to, because your lawyer is giving you all those answers, not only verbally, but following up in writing, you'll never have to worry about a Rule 3. I can't promise you you're going to beat every case, but I can promise you that your lawyer is going to do a competent, effective job. Right.
And if you don't hire Tom Brady, that doesn't mean he's a bad lawyer. You just got to get more money to hire Tom Brady, or you go in with, Tua Tagovailoa, or however you pronounce it.
Tua's not doing bad, but
He's not doing too bad.
Let's hop on to part 2 of our show today, the stand your ground component. So I'm going to read you the arrest report from this case, and we'll go through it from there. And then, ultimately we can get to what happened, but we can talk about it as if it hasn't happened yet. And perhaps we can discuss it as if I am consulting you as a potential client to hire you. Okay. All right. So here's the A form. This is the arrest report. And again, so that you guys are aware, arrest reports are sworn statements by arresting officers of those facts and circumstances that led them to believe that there was probable cause for them to make an arrest. Okay. Doesn't mean that it contains all of the information, just means that it's enough for probable cause. Okay. So here we have Officer X of the Hialeah Police Department. You already laughing already, aren't you, Ed?
Yeah, come on.
Okay. On July 9th, 2022, at approximately 11:12 a.m., units were dispatched to X location in Hialeah, reference a man attacked by his garbage collector.
12 a.m.?
Huh?
Did you say 12 a.m.?
No, noon. 11:12 in the morning.
Okay, 11:12 a.m. Got it. Yeah. Okay.
Upon arrival, contact was made with the victim, who stated that he was attacked physically and he was bitten on the left side of his face, while also being hit with the wheel of a garbage container. The victim was bleeding from multiple places in his face. He had a swollen left side where he said he was bitten. Contact was made with a witness who stated that she heard a commotion from her corner store. She looked out the window. She saw the defendant and the victim fighting, but she did not say anything about a bite or a weapon being used, nor did she see what happened prior to or what caused the fight. During an area canvass of the area, the defendant was seen around another part of Hialeah. According to the defendant, the incident did happen, but it happened out of self-defense because he thought he was going to be attacked. Defendant spontaneously stated that he did fight and bite the victim. Defendant was placed into custody for further investigation. Victim did a show up and immediately identified defendant as the person who attacked him. Defendant was arrested for aggravated battery and transported to the jail.
That's it for the A form.
That's it for the A form. I'll give you a few additional facts.
Okay, go ahead.
So you have a bigger picture. The defendant is the garbage collector for the victim. The victim owns a business in Hialeah. The victim has a one of those big garbage bins that he fills with refuse, and the defendant comes with the truck, picks up the garbage canister, dumps the stuff into the truck, puts the canister back, and takes off. This particular canister has a broken wheel, so it can't be wheeled out into the street. It actually has to be, you got to kind of hold it up from one corner and push it out to the street so that the truck can get to it. There have been ongoing disputes between the defendant and the victim for the past several months. The defendant's garbage business is a family business owned by him and his father. His father ran the business for 20 years before he turned it over to the son, who's been doing it for the last 10 years. The father does the paperwork in the office. The son drives the truck and does the routes. Capiche? Okay.
Both admit to that? Do both admit?
That's agreed. Those are agreed to. The father and the victim have had a business relationship for more than a decade. They consider themselves to be friends. This is also undisputed. The defendant and the victim, on the other hand, do not have a very good relationship. And this relationship began to sour about 6 months ago when the victim started putting what is bags that were labeled as hazardous materials in his garbage. So when the defendant saw hazardous waste bags in the garbage, he told the victim, I cannot take these because I don't have licensing to transport hazardous waste. Guy says, oh, it's not really hazardous waste. It's just a bag. Defendant says, listen, I'm sorry. It doesn't matter. If the bag says it, I can't take it. Please don't use them anymore. So apparently this has been an ongoing thing because the guy uses the bags and he doesn't use the bags, and the defendant needs to check the garbage. He literally needs to sift through the garbage, which slows him down on his routes and everything else. Finally, there was some late payment issues, and the father and the victim had spoken about that, and the defendant made an executive call and said, we're not going to service you anymore. So the day before this incident, which was the scheduled day of pickup, the defendant shows up. He exits the vehicle to go push the dumpster out so that he can pick it up with the truck. The victim comes out. They have a verbal dispute, and several of the victim's employees come out with the victim, and things start to get really heated. And this is not stipulated by both parties, but according to the defendant, 3 or 4 employees of the victim literally held the victim back, at which point our guy, the defendant, was actually able to get in his truck and leave without incident. So his plan was to come back the following day and literally pick up the canister, take the canister, leave, and be done with this guy. He shows up the following day. Nobody's outside. He goes to push the canister out, and out comes the victim. The argument starts, and this time the 3 or 4 guys who allegedly held him back the day before were not in front of him holding him back. Instead, they were behind him, maybe not cheering him on, but certainly not slowing him down. And at this point, my guy feels that he's in danger because this guy's coming at him and he's hot. And they've already been through the heated exchange the day before. So my guy says, you know what? I got no way to get out of here. This guy's going to get me before I get to the truck. There's 4 of them and 1 of me. And he goes to town. By the way, my guy, our defendant, gets a gash in his head that ultimately, when the police arrest him, they have to take him to the hospital. He has to get 6 stitches in his forehead before he can be booked into the jail. And the only other thing you need to know is that this case was filed as a felony for aggravated battery with a deadly weapon. Okay, meaning that this guy allegedly beat him with the wheel that fell off. But ultimately, the state attorney realized that didn't happen, and this guy didn't have any serious injuries, and they dumped it down and bound it down to a misdemeanor simple battery.
Now, here's my question to you. Does the victim agree to everything you just told me?
Victim agrees to everything I told you, except he does not claim that he was the aggressor. He claims that my guy charged him and started the fight.
Okay. So
that's
if you came to see me,
stipulated too.
First thing I'd tell you is, do you know of any independent witnesses that saw the fight started, and or do you know of any videos?
Okay.
Just the video.
Go.
Or the witnesses.
Here's the information on that count. We know that there were at least 3 or 4 employees present, both the day before and the day of the incident.
But that's the victim's employees, so they side with him.
Okay. None of them are listed. None of them are interviewed. None of them are preserved by any police officer on scene.
Okay.
The woman who they claim heard the thing but didn't see the thing is also not listed or claimed. There's no indication of any video or surveillance. However, I got hired very quickly on this case. I got hired. I mean, the guy bonded out of jail. It wasn't 24 hours, 48 hours after he got out of jail before he hired me. So I sent my investigator, who you all have met if you watch this show, Carlos Fuentes. I sent Carlos out to canvass the area. Carlos canvasses the area and finds two independent witnesses that work in shops nearby who say, we didn't see this, but we did see the day prior. And we do know that these guys have an ongoing dispute because we hear them yelling at each other all the time. He also found that the business that the victim owns has all sorts of surveillance cameras all around the periphery of the business. Because of that, and because there was no case filed, so I don't have subpoena power, I sent what's called a spoliation letter to the state attorney. That is, I sent the state attorney a letter that says, hey, my name is Mike Haber. I'm the defense attorney on this case. I represent this individual. My investigator was out at the scene. We know that there is surveillance equipment. We do not know if that equipment is working. We do not know if it was functional. We do not know what it captured. However, we do know it exists. And because I do not have subpoena power, I am putting you on notice. You need to talk to your victim about this. You need to ask him to preserve the video from 1 hour before the incident to 1 hour after the incident and give you copies of it because we're going to ask for it as discoverable material. Again, if I had subpoena power, I'd do this right now. And then I took the extra step of serving the registered agent of the business, the victim's business, as well as the victim himself. I served them with process with copies of that same spoliation letter asking for that to be preserved. So what did the victim tell?
That was the best thing you did, because the state could argue that if they didn't have the video, it's not in their care, custody, and control. He can't.
So what does the state get from the victim? 34 seconds of video showing my client on top of him.
No, not what's nothing before that.
Nothing before that, nothing after that. 34 seconds mid-fight. That's all they gave.
Have you gotten an explanation as to why he didn't
on the witness stand? Yes.
What did he say?
So this is a case where we don't take depositions. Again, we file a stand your ground motion. Our client. So what is stand your ground? Stand your ground is what we call self-defense on steroids. Okay. Self-defense says that if you are being threatened, if you have a reasonable fear of imminent bodily harm, if you believe that you, your property, or somebody else, you're allowed to defend others too, is in imminent danger, then you have the right to act. Traditional self-defense imposes a thing called a duty to retreat. Okay? That means, yeah, you're allowed to defend yourself unless you can safely get the hell out of there. And if you can safely get the hell out of there, then the law requires that you safely get the hell out of there. Now, there's a separate doctrine called the Castle Doctrine. And so this is for self-defense in your own home. Okay? If you're in your house, you do not have to retreat. You are in your home. There is nowhere to retreat to. You don't have to lock yourself in a bathroom. Somebody breaks into your home, you are entitled to use self-defense. Now, it still has to be reasonable. It still has to comport to the facts and circumstances, but you do not need to retreat. So stand your ground combines those two things together. And basically what it does is it extends the Castle Doctrine to the entire jurisdictional boundary of the state of Florida. So long as you are in the state of Florida, you have no duty to retreat, and you can use self-defense under Florida's stand your ground law. Again, it still needs to be both subjectively and objectively reasonable. So when you claim stand your ground, the way that you deal with that is, well, you don't have to, but one of the ways that you deal with that, the way that we deal with that, is in a pre-trial evidentiary hearing. And the hearing is seeking relief under Florida stand your ground law, which says if the judge finds for the defendant is granted immunity from prosecution and the case is over. Right. End of discussion, because the defendant should have never been arrested because the defendant acted lawfully.
Correct. Correct. And as a pro tip, as an aside, I recently had a case where they hired me after another lawyer had filed a stand your ground motion, and they lost the stand your ground motion on a motion that they should have clearly won. There's no doubt they should have won the motion because there's video surveillance of the incident happening where my client had a gun. He claims you can't hear what's happening, but you can see. He claims that earlier the day the guy threatened him, grabbed him by the throat. He knows the guy. He knows the guy's always carrying a firearm. They went to the beach together. He wanted to leave him at the beach. He didn't want to take him home at 2:00 in the morning because he says the guy was high on drugs and he was out of control. So he told him, I'm not letting you in my car. And the guy said, of course, yes, you are. I'm going to kill you, whatever. So the defendant grabs the gun, and you see it on video. He grabs a gun, gets out of his car, and he circles around the car to get away from the guy. And the guy comes around the vehicle and charges my client, and my client shoots him once in the leg and then drives off. The reason they lost the stand your ground, Michael, right? Because it sounds like, how could you lose that, right? You see the video where the alleged victim charges you, knowing you could clearly see that you have a gun. You haven't pointed it at him because he didn't testify. Nobody testified for the defendant. And the reason you're going to lose it is because what Michael said. You first have to show that there is subjective fear, and then it has to be objectively reasonable. If he doesn't testify to say, yes, I feared for my life when this guy charged at me, the judge is not going to be able to grant you stand your ground. You have to have something.
Let me give you a little bit of the mechanics of how this works, because in criminal court, the government bears the burden of proof. Okay, the Sixth Amendment says the government has to prove you guilty beyond a reasonable doubt. That is their burden and their burden only. The Fifth Amendment says you do not have to testify. You don't have to prove anything. So when you take the Fifth and the Sixth together, everything is on the state, and the defendant gets a presumption of innocence, unless and until the state overcomes that burden. But there are certain things that you can do to shift the burden, okay? And one of the burden shifting rules is what's called asserting an affirmative defense. So if you allege stand your ground, you ultimately have shifted the burden to you. You now have the burden of proving that stand your ground is a viable defense. And if you do that, then the burden shifts back to the government to rebut that presumption. Okay, I'm not going to get into the minutiae of the standards, but the bottom line is the defendant must cross that threshold by proving that stand your ground is legally appropriate in this particular case. It's what we call making a prima facie showing. Okay, so you can do that by way of a sworn written motion, or you could do that by way of testimony, or you could do both. But if you don't have at least one of those, theoretically, you should not even get a hearing.
Right.
That's number one. Number two is that if you do put on your case, the government then needs to rebut it. Okay. And then the defense gets to try and rebut the government's rebuttal.
Right.
So it's kind of like a ping pong game. So what happens here is we file a stand your ground motion. Okay. That triggers an evidentiary hearing. The state then has to put on evidence to prove to the court by clear and convincing evidence that the defendant's actions are not properly immunized. It was not lawful under stand your ground. Okay. And if they do that, then theoretically we ought to lose, but then we get to put on our own case if we choose. So in this particular instance, and I find the state does this a lot, they call the victim and nobody else. And it's very difficult to prove. In civil court, it's a lot easier because the burden of proof is a preponderance of the evidence, right? More likely than not. Just tilt the scale just a little more one way than the other and you win. You don't have to go to any length or extent like in criminal court, proof beyond a reasonable doubt. It's a very, tall cup of water there. That's a high standard to meet.
Or in this case, clear and convincing.
So here it's clear and convincing, which is a little bit below reasonable doubt and a lot higher than preponderance of the evidence. So if it's a he said, she said, right? You don't have anything else. All you have is the defendant saying, I acted reasonably in self-defense, and the victim saying, no, he didn't. I don't know how the state reaches a clear and convincing standard with that. Now, if they put on a police officer, if they put on another witness, if they introduce some evidence, if they have something to corroborate the alleged victim's testimony, yeah, okay, well, that's how you get there.
Or in the case of this client that came to see me, and if the state puts on the witness and the defense puts on nobody, it's not even a sworn statement is not going to be enough. But all they did was file a motion, which triggered, like you said. Now the state has to prove it. Well, the state brought this guy. I'm assuming this guy said, I didn't try to attack him. He had no reason to fear me. The person who was scared was me. Okay.
Well, that's a pretty good ineffective assistance of counsel claim, going back to 3.850.
Right. Counsel, defense counsel, do you have anything to say to that? Nope, we got nothing. What do you think the judge is going to do?
So in our case, the victim, we made a prima facie showing with our written pleading. So the state went first. They call their victim takes the stand, and he basically admits to everything that I told you on here, except, as I said, he indicated that he was never an aggressor and that our guy was out of control, angry, attacked him, Attacked him the day before, attacked him this day, attacks him every chance he gets. He's violent, he's dangerous, he's out of control, blah, 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 blah. They try to get in the video, and we were successful in blocking entry of the video into evidence because we argued two things. Number one, we argued what's called the rule of completeness, okay? And the rule of completeness says you can't just do what the news media does all the time or what politicians do in political ads where they take one teeny little clip out of something and they don't give you any of the context of anything else that was said, right? So that 34 seconds is great if you have the rest of it to look at, right? We want to see what happens from the time my client pulled up until the time that my client drove off so that we know the full context and not just that cherry-picked 34 seconds. And the rule of completeness says if you don't have it, you can't introduce it. So that was one ground to keep it out. But the other ground to keep it out was fascinating. So the victim testifies on the stand that when the police were there, they asked about the video equipment, and they the defendant's, the victim's son, who's the electronically competent individual who was on scene, went into the back office with the police officers, showed them the video, and this was the clip that the police officers asked for. This was his explanation as to why there was only 34 seconds.
Their explanation is the cops went in the back, saw the video, and the cop said, I only want this.
This is all we want. Just give us this 34 seconds. So this guy testifies to this under oath. Now we recess and we ask the judge and we inquire of the state. First off, we got the tape from the state. We didn't get it. We got it from the state after the case was bound down from county court. It didn't come in original discovery. So we asked the state to reach out to their officers and verify if since they didn't have any police officers in the courtroom, there was nobody coming in to testify, verify whether or not what the victim testified to was accurate. They got a hold of their officers, and both officers on the case told the state attorney, and the state attorney represented the court, that they never went into the office, they never saw any video, they never impounded any video, they never asked for any video, and if the state has any video, it did not come through the police department, it came from somewhere else. So that was a big problem for the victim because that's a major credibility issue when he's testifying that something happened and the state attorney's throwing their hands up saying, sorry, judge, it didn't go that way. So we were able to keep that piece of evidence out, which probably would have been very damning because I'm sure that 34 seconds showed my client beating the crap out of this guy. And by the way, the police did take color photos that the state blew up on big poster boards of this guy just bloodied. I mean, he looked like Dusty Rhodes in a 1975 match against, Jack Briscoe.
Only this was real blood and real fights and real
blood back then. They used to go down to the ground and they would take a razor blade and slice while
really?
they were down. Yeah. So anyhow, he didn't look good. And on the flip side of the coin, my client didn't look good either, including when he did take the witness stand after the state rested, we put our client on, and he gets up there and points to it and says, well, judge, this is the scar I got. And he did. He had 6 stitches. He had a little Frankenstein thing on the side of his forehead.
But I have okay, go ahead. I want to ask you a question when you're on.
Go on.
Are you telling me the state went forward even after the cops said this guy lied?
Absolutely.
That's the part I don't understand, Michael. We were not trained that way.
Well,
That's not what first of all, so everybody understands, right? Ethics of a lawyer, of any lawyer, be it civil, criminal, prosecutor, defense attorney, civil lawyer, family lawyer, anybody. One of the things that's beaten into us as far as our ethics is that we can never put someone on the stand that we believe is going to lie, right? It becomes a huge ethical dilemma for defense attorneys when our clients say, I want to testify, but we know he's going to lie. And attorney-client privilege says, well, we can't tell the court he's about to lie, but also ethically, I'm not allowed to put him on the stand because I know he's going to lie. That's not an ethical problem for the state. I don't understand why prosecutors don't understand this and how they're not trained for this.
Well, I'm going to take it a step further.
I'm sorry, Michael, but I'm pissed. I'm sorry. Let me just, you've got 2 cops, not 1, 2, who I don't see what their motivation to lie would be, but let's say it's 1. I don't see any motivation, but you got 2 that say this guy is lying, and you still went forward with that case. I have a big problem with that. As a former prosecutor, it bothers me. I love that job, and I respected that job, and I took that job very seriously, and I took it very ethically. And the prosecutor's job is justice, not to prosecute people.
Well, unfortunately, they're not trained the way that you were trained today. They're not trained that way now. And I will tell you that I have now done, I don't know if it's 13 or 14 stand your ground hearings. I'm batting 1,000. I haven't lost one. Every single one of them, before they get litigated, they get filed. I draft them.
Unbelievable.
Before I file them and draft them, I approach the prosecutor and I try to have a conversation and say, listen, here's where we're going with this. And I think you need to talk to your victim and see, if what I'm telling you is accurate. Look, I don't like to tell anybody how to do their job. The point is, I give them a preview of what's to come. In each and every instance that I filed one of these stand your ground motions, the prosecutor has blown me off like I'm some sort of an idiot or a liar or a jackass. Then I file the motion. Okay?
You are a bit of a jackass, but not in those situations.
Now that they get the physical motion in front of them, you'd think that they would now do the diligence that they should have done before the motion.
In fairness to the prosecutor in your case, they may not have even thought to ask, are you lying? Or thought to ask the officers. I don't have a problem with that. But I certainly have a problem once you find out that the witness is lying. Once you know that your witness is lying. I had a case similar. I had to stand your ground, remember? And it was a related case. We had the husband with a tampering with a witness, and we had the wife who was charged with ag assault with a firearm. We did a stand your ground, same victims. We did a stand your ground with the wife on the ag assault with a firearm. And throughout the hearing, it was painfully clear that the victims lied to the point where the judge, in her order, said part of the reason she ruled this way is because the victims are liars. And we had a trial on the husband, like 3 weeks, set for 3 weeks later. And I brought this to the prosecution. I said, are you listening to this? You have a judge who heard your guys testify to the same incident, and they're claiming that the judge is saying that they lied. You still want to go forward, and they wanted to go forward on a tampering with a witness. We're not talking a murder. We're talking third-degree felony tampering with a witness, and they still went forward. And then during the trial, before we even started at the hearing, the officer lied twice before we even started the trial, and they still went forward with that case. And I don't understand how they're not getting this training. I don't understand it. I'm shocked. I don't get it. To quote Bill Burr, I can't wrap my head around this. I just can't wrap my head around this.
Well, as I said, I think, it's really shameful. And I call it, the first step is what I call piss poor policing. Piss poor policing. Because the truth is, the cops did not conduct any kind of a meaningful investigation here. They admit in the A form, my client said self-defense. They did not look at any of that security footage. And had they looked at that security footage, they may have seen something that said to themselves, you know what, maybe we shouldn't make an arrest.
Right. For all you know, they asked the owner, do you have security footage? He said, oh, no, those things aren't working. We don't know. We don't know what said to them.
I don't know, but I call it piss poor policing because that's the first step. If the police arrest somebody that the court ultimately grants immunity to, that arrest should have never been made. That's the bottom line.
True.
Now, maybe 20/20 hindsight, and I do give the police the benefit of the doubt that sometimes they don't know everything. For example, I had an SYG about a year and a half ago, a little over a year ago, where my client was on probation. And so he specifically did not tell the cops anything. He invoked and he said, I'm sorry, I'm not talking to you guys without my lawyer present. And he did it on purpose because he didn't want to wind up in trouble in terms of his probation violation on top of everything else. So he kept his mouth shut, knew he was going to jail, and knew he'd have an opportunity to talk to me, and then we could, figure it out intelligently, which I think was very smart, if not convenient. But my point in that case was that incident occurred right in front of a Ring doorbell video. There were 8 police officers on scene, and not one of them asked about the Ring doorbell video. To me, that's piss poor policing. You are supposed to canvass an area. You are supposed to make observations of a crime scene, and you are supposed to preserve evidence for a prosecutor and a judge and a defense attorney and a jury.
Unfortunately, I think our cops are becoming a lot like our school teachers. There are some out there that are fantastic, who do the job because that's what they want to do, who do the job because they want to be really good cops and they want to serve the community, be teachers because they really want to help kids learn. But unfortunately, there's also a lot that are just doing it for a paycheck. They're
Well,
doing it for a paycheck, and they're not really doing a good job because they just don't care.
let me wrap up this subject by saying, apart from piss poor policing or piss poor police work, it's also pathetic prosecution. Where a prosecutor simply doubles down on a bad arrest instead of opening his or her eyes, ears, and senses to the possibility, however small, that a defense attorney may actually be telling them the truth.
I know we've gone over a few minutes, but I got to get this off my chest. I am not saying that prosecutors should not prosecute. I want to be crystal clear with everybody out there. And if any prosecutor or judges, or if Kathy's listening, first of all, I know Kathy would agree with me because I was trained under Kathy. I don't think Kathy understands what is going on in this office. I've seen way too much of it. I'm not saying you don't prosecute. You don't just dismiss or get rid of cases because the case is bad or the cops didn't write a very good A form, or if it's a bad dude or a bad woman and they committed a heinous crime and they just are smart enough to try and get away with it. That's where you need a prosecutor with some balls. Okay. You need the prosecutor who's going to keep investigating to get enough evidence to prove it beyond a reasonable doubt. That's not what I'm talking about. I'm talking about things as basic as the victim is lying, and then you're going to put him on the stand. That's just reprehensible, unacceptable. The cop, you find out your cop is lying. You cannot put someone on the stand as a prosecutor, especially as a prosecutor that you know is lying. If you even think they're lying, you have to really be like, oh my God, I can't. I got to work this case out because I'm pretty sure this person's lying. As a prosecutor, your job is not to do that. I'm not saying be soft. You know me. You remember as a prosecutor, I was a ball buster. And I would never have done something so unethical in my life. It is unacceptable.
Well, let me just say that I am not on a first name basis with Mrs. Fernandez Rundle like you are. But I think
She's a great person.
I think they do need to invest a little more time in training over there because these, especially the younger prosecutors, the last three I've had have been in three of the last four I've had have been in county court. And so these are young prosecutors. And I don't blame, there's a learning curve here. But there should be supervisors. There should be better trained attorneys, more experienced attorneys looking over their shoulder and giving them some guidance so that they don't take cases like this.
Right. And I'm not saying they're not going to make mistakes. Of course, you're going to make mistakes. But putting someone on the stand that you know has been called a liar, Michael, you know what? That's not a lot of training needed there.
No,
not a lot of training needed.
But I think it's part of vetting a case and really understanding what it's about before you begin. But look, we're already over time. So I know you're very passionate about this amongst other things, but I don't want to run over too much more. So I do want to wrap up and thank everybody for you letting us indulging us for a few extra minutes and listening to me complain about the last 2 weeks of my life or express to you what my experience was and why we didn't have shows on the 31st of October or November 7th. But the good news is I don't have anything on my calendar next Monday, which happens to be Revolution Day in Mexico. So maybe we'll have a cerveza or two during the course of the show.
I may or may not have depots, so you may be alone on.
You'll let me know, but I'm certainly.
Hopefully, because that's the other reason I set depots. Sometimes when you know the case is that bad, the state is just waiting for you to say, I'm going to get the witnesses under oath and ask them this under oath. We really got to go. Some of them make me do it. So maybe we'll get a plea and I don't have to take the depot.
We'll see. Either way, thank you all for paying attention, for joining us, and for listening to us. I hope you got something good out of this show today. You learned a little something about Rule 3s and effective assistance of counsel, as well as stand your ground and how those immunity hearings go. With that, I want to thank our producers for putting on a great show today. Edward, thank you for joining us.
Thank you, man. You look good with a tie. You should do it more often.
Hopefully, huh?
You look good with a tie.
Yeah, I got dressed up for you. Hopefully we'll be back. Certainly I'll be here next week. Hopefully you'll be here as well. Either way, thank you folks again, and we'll look forward to being at your service next week on the 21st. Take care and thank you again.
Take care.